Each side will have 15 minutes to present their argument, and the appellant may reserve up to 5 minutes, just like any other. Thank you.
Thank you, Your Honor. May it please the Court, Mark Jones representing the appellant, DuWayne Detamore. I would like to reserve 3 minutes for rebuttal. Your Honor, the issue before us today is whether knowledge of an untried indictment can ever be imputed to a warden based on the fact that that knowledge is probably within the possession of the court and the prosecutor. I believe this is an issue of first impression. That's my belief. I think we need to start with the constitutional point that comes from Barker versus Wingo, that this is a fundamental constitutional right, and that in that case, the Barker case, the court stated a number of things which I think are interesting and informative when we look at this issue, and that is, the court said there is no inflexible rule in deciding this issue of speedy trial. It rejected the demand waiver rule, saying that you cannot waive this right by failing to make a demand. It said that the primary burden for the notice is on the state, and it said that the burden is not solely on the defendant. Now, admittedly, that case did not deal with the statute, but the intention of the legislature in enacting the speedy trial statute is to protect the constitutional right. And the case of State versus Bayless, the 1998 Ohio Supreme Court case, said that speedy trial statutes and constitutional rights are coextensive. The Barker case initially said, I believe it was the Barker, there's another case that I cited in my brief, that indicated that essentially the statutes are a floor, and that sometimes the constitutional right is stronger than the statutory right. And when that is the case, you get the benefit of the right to, in this case, it would be the appellant. Now, I notice in the state's brief, it makes several arguments based upon waiver and then waiver of constitutional argument. The waiver arguments, if you go in and look at the cases cited by the state, every single one of them involves a guilty plea. That's they involve guilty pleas. There's no guilty plea here. There's a no contest plea and a motion filed. The right is preserved. I would cite the State versus London, which is a Supreme Court case, Ohio Supreme Court case from 1982. On the waiver of the constitutional argument, I think I've essentially just addressed that, the coextensive nature of the right with the statutes, the fact that the purpose of the statute, the legislative purpose of the statute, is to invoke the constitutional rights. So if we have a case that, where the motion that is filed refers to the statutes and not the Constitution, I don't think that means that you don't have a constitutional argument. That would make more sense to me. The issue in all of the cases, starting with Barker versus Wingo and proceeding to the cases that in particular involve the statute in this case, 3941-401, they all deal with knowledge. Why is that? Because if you go back to Barker, Barker says that the way you analyze the issue is by examining the knowledge and the conduct of the prosecution and the conduct of the defendant. Essentially, you allocate fault. All of the decisions are based on knowledge, essentially conduct. And that is why the state, in its brief, makes 13 references to the state's lack of knowledge of the defendant's whereabouts. And at the same time, the state acknowledges that there was probably, perhaps, negligence on the part of the state. Barker versus Wingo cites knowledge and conduct at pages 529 and 530 of that opinion. In our case, the facts indicate that the claim of lack of knowledge of the prosecutor is really hard to swallow. The argument is basically, yes, the common police court was sending judgment entries to the defendant, and presumably, in every case I know of, when it does that, it sends a copy to the prosecutor. But it was a different judge and it was a different prosecutor. I don't remember anything in the record that said it was a different case or a different prosecutor. It was the Wayne County Common Pleas Court that was issuing the judgment entries on motion for time served, on motion for judicial release, and another one, I believe. So during this time period, the court was getting motions, responding to motions. They would copy the prosecutor on them. So I find it hard to believe that there was a lack of knowledge.
So what you're asking us to hold certainly goes beyond just the Wayne County Prosecutor's Office. Are we to come up with a ruling that applies to all of the prosecutor's office in the 9th District jurisdiction that says that any filing by a defendant in a case that is sent to the prosecutor's office, the knowledge of that filing is imputed to every prosecutor in the office?
I don't think it has to go that far because that's very fact specific. I think the ruling that I'm asking for is one that says when the facts demonstrate or seem to suggest that knowledge of the impending indictment is probably within the possession of a court or a prosecutor, that knowledge can then be imputed to the warden. And the closest precedent we have is 15AP, which is not exactly, that's a substantial compliance case. This is not a compliance case. But that is a case where the warden had no actual knowledge. And if you want to go back and argue unambiguous statute, the warden in that case had no actual knowledge. The knowledge was imputed to the warden. Who had the knowledge? The Alliance Municipal Court. Because the attorney for the defendant had sent letters to the municipal court and to the common pleas court, and they were acknowledged to have been received by the municipal court. So it was the court, not the prosecutor in that case, that had the knowledge. And that knowledge was imputed to the warden, who then has a duty to notify the defendant of it, the defendant without knowledge. So all I'm asking for is when you have facts that suggest that you have a court and or a prosecutor who has knowledge of it, that then be imputed to the warden so that the warden can notify the defendant. Because otherwise it's not fair. Otherwise all the duties, if you look at these right line rules or suggestions, cases that lead toward the right line, you see that what happens in them is that the duties all apply to the defendant and there's nothing that the prosecutor has, nothing that the court has. And the problem I have with that is that when you look at these cases, especially the ones that talk about inheritance, says, it's an unambiguous statute and so on. A wonderful example of this is the supplemental authority filed by the prosecutor 2 days ago, the Phillips case. The Phillips case is a case that actually mischaracterizes the holding of Harrison by saying that it was the holding that it was not an unambiguous statute. It was part of the reason that it was dicta. But then it goes on to misapply the statute, the plain language of the statute, because the plain language of the statute puts a duty on the warden to send a certified mail to both the prosecutor and the court. And it did not do so. And they found in the facts of that case that because the certified letter hadn't been sent, because the clerk hadn't received it, that therefore the defendant loses. But it was the conduct of the warden that was at fault there, under the plain language of the statute, which was being directly applied without interpretation, whatever that means. So what I'm suggesting is that these cases are not, they're all over the map, and they're not simple cases. It's not simply a case of applying it as in the statute. You have to be careful with it, and I think you have to look at them in the context of the constitutional right. The constitutional right says, what I just said about what Barker says, it's the responsibility of the state, more so than the defendant.
The state points to speaking of knowledge, to the knowledge that your client had in light of the fact that he was present when the search warrant
That issue is very tricky because here's one of the things. I pointed out in my second assignment there, the very last paragraph. I said one of the problems with this case is that we did not get a hearing. If we had had a hearing on this case, we would know when the defendant knew what, when the prosecutor, which prosecutor it was, when that prosecutor knew what, and so on and so forth. We would have answers to those questions. The court rules without a hearing. So all we have is the record of the sentencing hearing and the motion, which was not disputed, the motion to dismiss, which was not disputed. Facts there were not disputed. If you go back and look at the sentencing hearing to get to the issue of the knowledge of the defendant, he says two things regarding his knowledge. One thing he says is that he was the first one on whom a confidential informant was used. There were other defendants, and then he says his house was raided at some point. We don't even know whether he was there when it was raided, because there's no hearing. We don't know when he learned about the other indictments. We don't know anything except that other people were indicted, and at some point he became concerned about this. But he never says, I knew that I was indicted, unlike the other cases that are referred to. You know, the Harrison case where there was knowledge, and the other cases where the defendant has some kind of knowledge. He really had no knowledge, and the record doesn't clarify what knowledge he had. All it says is those two things. I was the first one to get the confidential information, and second, my house was raided, and the implication is, in the sentencing, he's complaining that others were treated differently. And that was the issue I raised in my second assignment here. So I don't think it's very clear, and I think the problem is no hearing, and I think that's going to come down on our side. Now, if you get back to the factor analysis that the state talks about in this brief, the state's going to emphasize the fact that, well, you've got these factors on the constitutional issue coming from Barker. They don't really apply to your guy because it talks about pretrial incarceration, and it talks about these other issues that deal with prejudice to the trial, for example. This wasn't the case where there was a trial. But what Barker says is those factors are not exclusive. And there's a case that says where bad faith delay would make relief virtually automatic, neither is negligence automatically and automatically tolerable simply because the accused cannot demonstrate exactly how it has prejudiced him. That's State versus Walker cited to Gaudier. And Barker says prejudices to the personal prejudice is not always identifiable. Page 531 of the Barker case. None of those factors is necessary or sufficient, says Barker. Okay, so the one thing I would say is that sentencing is as important to any defendant as guilt or innocence. And I've done that for 17 years. I know that's the case. Thank you.
May it please the court, Mr. Owens, Nathan Shaker on behalf of the appellee, the state of Ohio. Obviously, I would frame the issue in this case very differently. Though in the state's brief we address the constitutional factors, what Mr. Owens and Mr. Detamore are asking this court to do put any trial court in an untenable situation when you look at the motion to dismiss that was filed in this case. The motion to dismiss entirely focused on the statutory factors. As Mr. Owens acknowledged, the constitutional speedy trial precedence, it is a broader concept than these statutory speedy trial provisions, specifically this one which deals with inmates and is so narrowly tailored and has been narrowly seen as narrowly drawn by courts in dealing with the ambiguity in terms of the obligations of the state and the warden and taking care of inmates who are in custody. Specifically, the arguments about negligence and placing blame were never reached by the trial court. Those issues were waived. The trial court specifically looked at the statute, which Harrison said is not ambiguous. There's no requirement for reasonable diligence on the part of the state, and the obligation is on the defendant to send notice. That's what the trial court was looking at. The trial court looked at Harrison and this court's decision on Druzik, which again reaffirmed that there is no reasonable diligence requirement on the state. In terms of placing blame, that was never before the trial court because the constitutional aspect was not raised. It's not appropriate to raise it at this juncture.
But we will agree that the way that the statutory language reads, places a responsibility on the defendant to act. And in order for him to act, he has to have knowledge of proceedings against him.
Yes.
In this case, he was secretly indicted.
And that's a common sense requirement. And in terms of reaching that, again, if the Detamore's argument is essentially that unless you get that paper, unless you are arrested, you don't know that you committed a criminal act. I think that's short-sighted when we're talking about all this knowledge. If you did something illegal, you might know. And defendants routinely send these things to our office, to other offices, saying, you know, I might have something out there. And what triggers it is him filing something in another case, in a different case, enough for the state to have to make an affirmative step to serve him. I don't believe that's a realistic expectation when there are so many defendants, there's so many filings in any given court case. Mr. Owens talked about Santafonte, 5th District case. That case is completely different in that the defendant made an affirmative step, but when you read that case, it appears that he had some knowledge either through receiving a summons. It didn't appear to me that he was arrested in that case, but there was something else beyond just the state having this general obligation at all times to inform him. The defendant was put on knowledge by something else.
Could you conceive of a circumstance where a defendant in a case is secretly indicted and he has no idea about proceedings against him? Okay. So not this case, but a case. There's no grade, there's nothing like this.
Yes.
But the state has evidence that they secretly indicted. That defendant finds himself in custody on some unrelated charges, doesn't know anything at all. And this situation occurs. You have other people who advise. What happens to that person as it relates to the notice situation?
I don't think the statute is contemplating that. That person's constitutional speedy trial right may have very well been violated. That's when it comes to raising it properly. I mean, generally, in terms of notice, this is what the statute has given us. Maybe it's poorly drafted to some extent, but I don't believe that that's enough to declare the statute unconstitutional. The violation would be on their constitutional speedy trial right, and you have to do that four-part weighing of Barker versus Wingo in terms of who is at fault, the amount of prejudice, the amount of delay. Obviously, if somebody sits there for 3 years and there's bad faith on the part of the prosecution and all those factors, there's a remedy there, and that's what the constitutional speedy trial right is necessarily for. This statute, 2941.401, is kind of akin to the interstate detainer statute in that it's dealing with a specific, I believe the legislative intent is to deal with a specific instance of what a warden has to do, what an inmate has to do. In terms of what generally the state has to do, that's subsumed by the constitutional speedy trial. And I think that's the big issue in this case, is whether you can even get to that constitutional speedy trial right. I don't believe in the defendant's first assignment of error that that's properly before the court. It's specifically the statutory language, which the trial court did not err. It followed binding precedent as best it could with what was in front of it. In terms of the defendant's second assignment of error about the statute being unconstitutional as applied, it's not clear. There's an equal protection argument, and I believe there's a due process argument, how he's claiming that he was treated differently than similarly situated defendants. There's some reference to the co-defendants in the case. They're clearly not similarly situated. They weren't incarcerated this statute wasn't applied to them.
Do we know that from the record?
No, I don't believe so. It's not clear from the record. But also, just generally in terms of both assignments of error, Mr. Detamore speaks about knowledge, and our position is that he had some knowledge of this. That's indicated on the sentencing transcript when he talks about the rate. It might be less than clear, but there is some knowledge. He could have done something. The statute isn't unconstitutional as applied to him because, again, he didn't do what he was supposed to do. And based upon his lack of compliance with the statute, our belief is this is a statutory issue, not a constitutional issue. The trial court did not err in how it considered the statute in this case. Thank you.
With respect to the defendant's statements at sentencing, with respect to the other people, the disparate treatment issue, I believe in the sentencing hearing, that's the only one where you get to hear the defendant talk at all. There's nothing at the change of plea except yes, yes, yes. He refers to, I don't remember his exact language, but it's essentially the argument that other people are getting concurrent time and I'm not getting concurrent time. How come I'm not getting concurrent time? There's no good answer to that.
But that begs the question as to whether or not there is any establishment in the record of similarly situated. Other people are getting concurrent time, but, how are they similarly situated? And I don't know that
we know, that's one of the problems we didn't have a hearing. See, so much of what the prosecutor was just talking about toward the end of his presentation and my attempt to address these issues is limited by the fact that we do not have a transcript which tells us who knew what when. I think that is one of the problems with this case, and that's why I mentioned it in error number 2. But the sentencing hearing is all you have, and it says he says my house was raided. He says other people, in effect, I can't remember his words, are getting different treatment than me. But we don't have all the details because we didn't have a hearing and we don't have a transcript. I think, this is a different case from all of the other cases that you have. You can go toward bright line, or you can pause and look and step back from the bright line. I think the latter is the better course because this is a constitutional issue any way you look at it. Whether it's statutory or not, it's still a constitutional issue. And when you get to the plain language argument, there's plain language in the statute that describes the warden's duty. That's a precedent duty. It must be precedent because until he does that, assuming the defendant who does not know, it must come before the duty of the defendant to give his notice. So, there's precedent duty on both sides. Just to say, as Hairston does, that the initial duty is with the defendant, well, in which situations? The court doesn't really answer that question. It's a different result in Dillon because it's different facts in Dillon. And so all these cases have different facts in this particular case. And I think the proper way to come down on it is to stick with the Constitution.
Thank you, gentlemen, for your presentation and your support today. We'll take